Don't lose it. Thank you all so much for joining us. Welcome to the Senate Judiciary Committee hearing. We have, as always, sign-up sheets up front. Please come up and sign up if you want to be heard on one of the bills. And we're going to start by opening up with a word of prayer. And I'll ask Senator Rhett, I didn't prepare you at all, but if you don't mind, open us up. What's your mic number?
5.
Mic 5. If y'all please bow with us.
Thank you, Mr. Chairman. Bow our heads. Oh, Lord, we thank you for this day, another day's journey, an opportunity to do the people's work. We ask you to give us your wisdom, and as we go forth on this lengthy agenda, using wisdom from you and working together as a team here, because when 2 or 3 are gathered, there you reside with your wisdom, and we thank you for that. And we ask these things through Christ the Lord. Amen.
Amen. Thank you. I'm supposed to start by recognizing all the judges in the room, but there's so many of y'all, I'm afraid I'm going to miss somebody. So I'm just going to say thank you all for joining us. And some of y'all, I think, are going to be testifying on some of these bills. And I know, welcome back our last year's, maybe the year before, last year, Judge of the Year, Judge Guy. I won't recognize anybody else, but good to have you back in the room. I gave him a hard time about not being here, so I do want to at least recognize him. But I appreciate everyone for joining us. And we are collecting all the sign-up sheets. We will go to the agenda. We have a lot of committees going on, and so I'm going to be playing some of this by ear as we go, but I know that Senator Tillery is not currently available, and so we're going to move past the first bill on the agenda, and we will circle back. We'll go to the second. I know this next person is here. Our Pro Tem Kennedy has the next 2 bills, so we'll start with Senate Bill 414. Do you want to do it from your seat up here? That's fine. So we're going to go to Senate Bill 414, and correct me if I'm right, we're working off LC 560129S. Is that the most recent substitute?
It is, Mr. Chairman.
All right, let me get your mic on. Which mic number are you? 12?
Number 12.
There you go.
Yes,
all right,
thanks.
the floor is yours.
Okay, thank you. So, Senate Bill 414 seeks to really protect donor information from unnecessary government collection and disclosure. Donors that contribute to causes that they believe in should be able to do so without fear of government interference. The sort of beginning precept of this is charitable organizations do a lot for society, and donors ought to be encouraged to continue to do that. And the best way to do that is make sure that we have an environment where donors are comfortable in making donations and continue to contribute to charitable organizations. The Constitution protects this freedom of association, and the 14th Amendment protects the freedom of association as a fundamental aspect of liberty, as well as the First Amendment, of course, to free speech. Government attempts at intimidating civic and advocacy organizations through forced disclosure of donors and members goes back generations, and unfortunately has been the subject of behavior from various groups, and one of which that produced the 1958 landmark decision NAACP versus Alabama. This bill protects nonprofit organizations from having to disclose the personal information of its members and donors to public agencies, except in some very narrow circumstances, which really fall under 3 sort of categories. First is when that information is necessary to be supplied in the discovery process. Second, if it is needed to be provided pursuant to a lawful warrant that has been issued. Or third, when the parties are engaging in contractual obligations to the state and that information needs to be provided. When personal information is properly disclosed to public agencies, the bill protects it from public disclosure by penalizing the unlawful release of it. This bill does not affect the required disclosures related to campaign organizations or registration as an entity doing business in the state, nor the current processes that state agencies have to regulate the licensed non-charitable businesses such as nonprofit banks or credit unions. There are teeth baked into this proposed legislation, and you'll see that the penalties begin at line 87 in the bill and provide that a declaratory relief and injunctive relief are available, and that if a civil action is necessary to ensure that someone's rights are pursued, that an injured party can be awarded up to, not above, but up to $10,000 or triple that amount in the event that the court finds that the violations were willful. An employee caught violating this bill can also be subject to criminal penalties as well. There's a detailed history, Mr. Chairman, of some cases, and I'm happy to go into that if necessary, but I know we've got a lengthy agenda. And I'm happy to stop there, but I did want to let you, Mr. Chairman, know, as well as members of the committee, that Megan Schmidt with the Philanthropy Roundtable. Megan, where are you? You're in the room right there. With your permission, if she could come forward.
Sure. Let me come up here.
And she can speak to the value of this within the philanthropic world, and certainly would ask her to correct any misstatements that I made about sort of the policy drivers behind this, if that's okay with you, Mr. Chairman.
Yes, sir.
Thank you.
All
Good
right.
evening.
Hi, how are you?
Good. How about you?
I'm doing well, thank you. Appreciate your guys' time today. I'm here to talk about Senate Bill 414, which really protects nonprofit donors to charitable causes. Senate Bill 414 would help to strengthen the vitality and breadth of civil society in the state. It would uphold a key pillar in philanthropic giving, the right of charitable donors to keep their giving private if they wish. There are a myriad of reasons donors may choose to keep their donations private, including, but not limited to, privacy concerns, religious convictions, and fear of harassment or retaliation. This legislation accomplishes the following: protects nonprofits from being forced to release personal information to state and local officials, prohibits government officials from releasing any personal information that's already in their possession, protects individuals and current or prospective government contractors or grantees from being forced to disclose nonprofits that they may have provided financial support to or otherwise. And finally, we do have a penalty section in there should this be violated. Without protections of Senate Bill 414, organizations will be at risk of violating the privacy of their donors. Georgia Charities do a lot of work and good work, and in the event of forced disclosure, that good work is put at risk. Charitable organizations run the risk of donors choosing not to give if they no longer have the option to do so privately. A few cases just to kind of give you guys an idea of kind of why this is important. I'm going to start with AFP v. Bonta. In 2021, the Supreme Court upheld donor privacy and concluded that bulk collection of information was unconstitutional. And this really led to about, I'm going to say 7-8 years prior, the then Attorney General in California had a sweeping demand for nonprofit donor lists and violated the First Amendment by disclosing those. A couple of other examples that come to mind. One, again, in California, and this was just in the past year or two, a bunch of registered gun owners, their names were released. While that's not necessarily donor information, that does go to show the power of the AG's office at times. And then you've also got, Prop 8, which is going back a few years, but donors, even minimal donors, were disclosed by California law, and they faced harassment, death threats, intimidation. We had one person, at least one person lost their job over a $100 donation. So this really is across the spectrum on both sides, and I'm happy to answer any questions and appreciate your time.
All right. Any questions from the committee? All right. Thank you. As one of the person that I think wanted to be heard, Mr. Gina Quick from DHS. Good afternoon.
Good afternoon, Mr. Chairman.
Welcome back to the Senate Judiciary Committee.
Well, thank you, Mr. Chairman, and members of the committee. I come here today to you in my capacity as General Counsel for the Department of Human Services. And of course, that is the Division of Aging Services, the Division of Child Support Services, and the Division of Family and Children's Services. This bill, of course, applies to all of the state agencies. And I come to you, and first of all, let me just thank the sponsor of the legislation and his staff, James Beal in particular, who we reached out to yesterday, and they've worked with us on some language, and I hope will continue to work with us on language, and that's really why I'm here to talk about language. as you might imagine in Judiciary Committee, that's what we talk about. And I come because the bill, in addition to addressing donor information, on lines 20, I don't know which line you're working from, Mr. Chairman. Are you working from a particular version of the bill?
We are on, the sub 0129S.
On line 28 of the bill, it applies, of course, to information regarding members, supporters, and volunteers. And certainly DHS has no interest in anybody's donors, but we have a strong partnership and predominant partnerships with providers that are nonprofits, and that is who we serve, which is our most vulnerable citizens, children, older persons, and disabled adults. So when you look at lines 84 through 87 of the sub, I'm here just to ask you to tighten up that language, and I have some proposed language, Mr. Chairman, that I'll just let everybody pass down the desk in the interest of time as you're looking at this and considering the bill. But what we really need to make sure that the department is able to do is to use what is defined as personal information in the bill. And that often involves getting lists of volunteers who might be around children so that background checks can be performed. And so there are a wide variety of circumstances where we have to get lists of individuals who will have to have access to personal identifying information and personal health information. And so in those contracts and the people we contract with, we have to be able to both obtain that information and ask for that information in the contracting process, as well as to ensure the compliance of our contractors and our vendors. And in certain circumstances, we have to ask for information from folks that we license in our regulatory capacity and with my Office of Inspector General. And so with that, Mr. Chairman, I'll leave you all with the language that I'm asking go in subparagraph 12 and answer any questions that there might be.
So can you provide some additional copies of your proposed language? And not everybody in the committee has it.
I have them,
The
Mr.
understanding, I'll let Senator Kennedy address this, but I believe there's no opposition to adding this language in. Is that right?
That's right.
Okay. And so you're talking about adding this language you're providing on lines 84 through 87, a substitute, or replace that completely and put this language in its place?
Please, Mr. Chairman.
Okay.
That would be my ask of the committee.
Who on the committee does not have the language? It's not in the folder, so yeah. If you have copies to share. Yeah. It might be good to give one to Ledge Council. All right. Now you have questions from the committee. Senator Parent.
Thank you, Mr. Chairman. Thanks, Regina. This may be better, more appropriately directed at the author, so I'll just go ahead and say it. So it seems that, and your testimony made a lot of sense, Ms. Quick, but I guess it looks like we're now sort of trying to exempt or do some workarounds for certain programs at DHS. And so my question essentially is, wouldn't there be similar concerns out of a number of our other state agencies with programs they run?
Senator, yes. Senator, I don't think so, and if so, we haven't heard from them. No one else has come forward, and I think this is a fairly unique set of circumstances where, as Ms. Quick talked about, you've got a fairly direct, significant relationship with a volunteer group or some volunteers. That's a little bit different, and also when you look at, I think it would be you would further limit the pool of potential concern when you think about the type of information that's being limited as well.
Yeah, I was just thinking, DBHDD and some of our other. Yeah, I mean, you may not know. I'm just putting it out there that wouldn't.
Sure.
Would seem odd to me if there were no other
Yeah.
agency that
I'm not aware of any,
similarly had?
but my preference is that we hopefully will move on this tonight. But if you find some that have the same concern like we've got with DHS here, happy to work with you as we get it moved to the floor or on the floor to make sure that similar type concerns are accounted for.
Thank you.
You're
Appreciate
welcome.
it.
Thank you.
Any other questions from the committee? Senator Calzert.
This is to the sponsor. I get it where people want to be anonymous sometimes when they make donations and ask to be, even in our newspaper, the Christmas Fund or whatever, where you make contributions, a whole bunch of them just say anonymous. This seems to apply to more than just people that request to make anonymous donations to organizations. It seems to apply to anybody working for a charitable organization or sponsoring them or giving their time or energy or whatever is kept private. Is that the intent?
It is the intent to be more broad than just those that donate and the details about the donations. And the reason is, if you read the operative language as this begins, really with lines 35, notwithstanding any other provision, a public agency shall not. And then it goes through the list of things that they are not to do and not to disclose. And that comes from this historical problem of agencies acting inappropriately, of disclosing information such as member lists, such as those that donate. And we've seen it on both ends of the political spectrum over the last 50, 75 years. So it's really an apolitical issue. It's been used by both sides, if you will. It's been used in ways that was harmful to across the political spectrum. And I think it has to cover more than just a donation. At times it has been used inappropriately, just exposing membership lists for a particular group that then brought harm to that person because they were associated with a nonprofit or a charitable organization.
One follow-up, please. Does it apply to anybody other than public agencies?
I'm going to ask Megan if she could, can you come back and make sure that I'm
May I be
answering that
excused, Mr.
correctly?
Yes,
Chairman?
ma'am. We'll see you at the next court
I
calendar.
don't,
Yeah, we're talking specifically about public agencies.
Okay.
I didn't think it
That's
did,
what
but
I
wanted
thought.
to make
Okay.
sure.
Thank you very much.
Any other
Thank you.
questions from the committee? What's the pleasure of the committee? We have, sold you quickly. Motion do pass by committee substitute. Senator Cowser, we have a second. Second from Senator Hatchett. Do you want to offer the amendment?
I'd like to, thank you, Mr. Chairman. If we could replace lines, and again, looking and working with LC 560129S as in Sierra, lines 84 through 87, which is numbered paragraph 12, the parenthetical 12, with the language. Do you want me to read it in the record, Mr. Chairman, or just is this sheet enough to document this?
Is she enough? Legislative counsel.
Mr. Chairman, it is fine. I would only recommend omitting the language referring to the official code of Georgia annotated, which we do not use in our code citation. So I would just stop at Title 49 and then go on to and
Okay.
as permitted.
Is everybody clear on the amendment being offered? Any questions about the amendment? Is there a second? Second from Senator Hatchett. All those in favor of the amendment, please say aye.
Aye.
It is unanimous. Back to the underlying motion do pass by committee substitute now is amended. All those in favor, please raise your hand. It is 4 opposed, 2. The motion carries. Moving on to the next bill on the agenda, Senator Kennedy, Senate Bill 450. You can sit there. We don't have anybody signed up to speak on it. We are working off of LC 491767S. Floor is yours.
Thank you again, Mr. Chairman. SB 450 is brought to us by the Judicial Council of Georgia as a follow-up to HB 916, which was brought in 22, as well as HB 186 in 2023. HB 916 was passed in 22 and it was known as the Superior and State Court Appellate Practice Act, and was a comprehensive update that simplified, improved, and modernized the municipal, magistrate, and non-Article 6 smaller county probate court appellate process to superior and state courts. To the members of the committee, certainly as the lawyers, you'll remember this was an extremely thick bill that Representative Leverett brought over that the state bar, I think, had worked on for maybe 2 years in trying to update the certiorari appellate process to the superior courts, and a lot of work went into that. It replaced the former certiorari and notice of appeal procedures with a single uniform petition for review process. 916 also created an easier way to navigate the process to promote justice, and made the process more hinged upon the merits than the procedural process or the procedural pathway for lawyers and litigants that had to go that way when appealing to the Superior Court. 916 passed out of both the House and Senate unopposed and became effective July 1 of 23. During the 23 session, though, HB 186 provided some technical and conforming amendments to the code that were overlooked as part of the bill we passed in 2022, as we often see happens when we do this type of comprehensive updates to certain parts of our code. The working group of judges and judicial counsel with the AOC staff have been traveling the state providing training to the bench and bar on this new provision. We have this substitute today, and it has, in essence, one main correction, and that is what we found in the version that was passed before. The language inadvertently changed how the appellate process was from an appeal from probate court, the right of a de novo appeal from probate court to superior court, and changed it to one of where there would be pursuant to an application to appeal to the superior court. That was an unintended change. We didn't mean to do it that way. The wording was not supposed to create that, but it did. And so this is simply the fix to that. Mr. Chairman, I think Judge Keith Wood, Probate Court of Cherokee County, Judge Wayne Purdom, State Court of DeKalb County, and Darren Enns, Judicial Counsel for the AOC, I think are here. And if they are, with your permission, I would ask them to come forward. Good. To help answer any questions or address any concerns, and certainly correct any misstatements that I've made.
Thank you all for joining us. Do you all want to be heard? Do you want to stand for questions? Seem reluctant to.
You guys are not helping
How
our
about I do
cause here.
this? Does anybody from the committee have any questions, unless there's something you want to add? We do have a question. Senator Cowser, get them.
I don't have my code sections memorized. On line 35, it says, except for convictions under Article 2 of Chapter 13 of Title 40. I know Title 40 is motor vehicles, generally are rules of the road. This would not allow you to appeal a conviction are these traffic offenses, or what are we talking about?
They're traffic offenses. I think it changed the way. I think it clarified what the appeal is. My understanding is, I'm not a traffic judge, but it's not a de novo appeal to Superior Court. It's just an appeal to Superior Court. So it's just clarifying that it's not a de novo appeal.
So it would be an appeal only as to some legal ruling or something. You wouldn't get a trial. Can you currently, if you try a case in probate court and lose a traffic offense, can you appeal that to state or superior court?
If I may,
Come up to the microphone.
Sure. Under the current code section for traffic convictions, it distinctly says it shall not be de novo. So we're cleaning that up to reflect what is the historical practice here.
Yeah.
So if it's accepted from the de novo standard of review for probate courts, it will default back to the default standard of review under a petition for review, which is on the record.
Okay. So if you are in probate court, you have a right to a jury trial. You could insist on that, have the case bound up or whatever. But you just can't have your cake and eat it too. You can't try it in probate and then appeal it for a de novo trial if you lose.
Well, if a probate court is handling a traffic offense, specifically that code section says that it cannot be de novo. And that's been historically the case, so we're not changing that. What the probate court judges recommended to us is that historically all of their other types of cases have been heard de novo. And so we wanted to get back to that. So basically, de novo would be the rule for probate court cases, but we have this exception where there's traffic convictions, which under a specific code section has historically said that cannot be de novo. That is on the record only. So this is just basically conforming to the way that it has historically been done.
Current practice.
Correct.
Okay, thanks.
Any other questions from the committee? All right. What's the pleasure of the committee? Motion to pass by Senator Hatchett. That committee substitute. Is there a second?
Guess I'll second it.
You better. Is there a second from
It was a
the
long
pro
pause.
tem? I know. It's a long time of silence. We have motion to pass by committee substitute. All those in favor of the motion, please raise your hand. It is unanimous. All right. Thank you all for your work on this. Thank you. All right. Moving to the next bill on the agenda, Senate Bill 465. Senator Goodman, welcome to the Senate Judiciary, Mr. Chairman. And we are working off a substitute, which is LC 491806S. Is that what you have?
Yes, sir. That's correct, Mr. Chairman.
All right, the floor is yours.
All right, Mr. Chairman, do you mind if I ask Mr. Gus Walters to join me up here?
Please.
All right, thank you.
Welcome, Mr. Walters. If you want to introduce yourself to us as well.
Thank you, Mr. Chairman. My name is Gus Walters, and from Valdosta, Georgia, and my son was Austin, who is named in this bill.
Yes, sir. Thank you so much for being with us and for being so brave and being willing to step up, you and your wife both, and share your story and share your son's story and make a difference forever moving forward by doing this. So I just want to say how much we appreciate you. I know this can't be easy.
Thank you.
Yeah. Mr. Chairman, this started, Gus has been a longtime friend of mine, and when he started emailing me about a year ago, after Austin passed away from buying Xanax that was laced with fentanyl. And I forwarded every one of those emails to the Lieutenant Governor, to his Chief of Staff, and his General Counsel. And I would read those emails and just find myself heartbroken. And he was really good. I mean, you would email me about once a month,
Yeah.
and every month I would be sending the email forward. And Senate Bill 465, what it does is it Austin's Law, named after Gus's son Austin, seeks to increase the penalties for these folks that are putting this poison out on our streets. In 2021, 106,000 Americans died from drug overdoses, and 70,601 of them were fentanyl. From 2019 to 2021, fentanyl-related deaths increased 124% in our state. What this bill does is it creates a new offense of aggravated involuntary manslaughter. And if you don't mind, Mr. Chairman, I would at this time, if you don't mind letting Mr. Walters sort of tell his story.
Yes, sir.
Thank you, Mr. Chairman. Thank you, committee. I would like to thank Russ and his committee and the Lieutenant Governor's office for helping us put this together. If y'all will indulge me, I'll share Austin's story. I've been stuck in a place for the last 28 months that I don't want to be in. I don't want our son's Austin's death to not serve a greater purpose. Our Austin was a lovable guy who everybody would want to meet. He never met a stranger. He loved the outdoors. He sold John Deere equipment for Ag Pro and loved every minute of it. He loved people. He sold to because they were his kind of folks. He was so good at his job that within the first 6 months of the company, he was one of the top salesmen in the country. He was so good that he frequently participated in sales training for new employees. On 5:30 Wednesday afternoon, September the 8th, 2021, I had just gotten home and was out in the yard, and my phone rang. I didn't get to hear it. It was inside. But my wife got a call from our youngest son, Thomas, and he was on the phone, and he was screaming something terribly wrong with his brother. I got on the phone, and all I could hear was my baby boy frantically saying, "Something is wrong with Austin," over and over again. He was on his way to my house. He pulled into the driveway, and about the time I hung up, we jumped in his truck and drove to Brunswick. On the way to Brunswick from Valdosta, everything is just a blur. I remember Thomas telling me that night, right before he got a call from Austin's roommate, and he found Austin unconscious on the floor in the bedroom, and they called 911. I felt a kick in my gut. My heart sank, and I began to pray that everything was going to be okay. Austin had stayed home from work that day. He and I had talked several times during the day. He thought he had food poisoning. He said, "Pops, at the end of the day at 5:30, I just need to go to sleep. I think I'll feel better in the morning." Austin had been feeling sick, but I knew he would feel better once he got a good night's sleep. I drove like crazy to get my hands on my boy. During our driving, we learned that Austin was non-responsive when they had found him, but the EMTs were able to revive him before taking him to the hospital. I thought to myself, there is hope. His heart's beating. We arrived at the emergency room, and I was escorted back to where Austin was. Thomas couldn't go. He was too scared. I walked in the room where my 29-year-old son laid with everything in the world hooked up to him. There were 2 or 3 nurses, an ER doc, working feverishly trying to keep him alive. All the machines beeping and people adjusting IVs and pushing intravenous fluids scared me to death. It was then that I realized my baby boy, my first son, was struggling to stay alive. I went to his side. I was in shock. All I could do was rub his soft beard, brush his hair out of his face. He had the best beard in the family. It was so soft and so full. He wore it like a man, but he was my baby boy. I prayed, praying that this was a nightmare and that he was going to be just fine, praying that suddenly he would look up and his eyes would open and he'd say, "Hey, Pops." He called me Pop since he was in middle school. He actually gave me my grandfather's name before I became a grandfather. I just knew he was going to wake up and say, "Hey, Pops," because he was a prankster. He didn't. He lay there in the ER bed for 4.5 hours, and I spent every minute with him except when I went out to check on Thomas. I prayed over him. I talked to him. I laid on his chest. I kept running my hands through his hair, and I cried like a baby for hours. I can still feel his beard. I can still feel his hair in my fingers. It's so real. I didn't want to leave my baby boy alone. He needed me. Thomas came in a couple of times to see Austin that night, and for me it just made things worse. His best friend, his protector, his big brother was lying there helpless, lifeless, struggling just to take a breath. It was heart-wrenching. Due to the swelling in Austin's brain, he had to be transported to Jacksonville to be with a neurosurgeon who could possibly save him. Before we left Brunswick, the doctor told me he was suspected fentanyl poisoning. It was that common in that area that that's what they suspected. They'd seen plenty of it. He told me it was going to be a miracle if Austin made it through the night. My prayer life changed that night. They were going to air flight him to Jacksonville, but they couldn't because of a storm, so he went by ambulance. Because we were in the middle of COVID, we couldn't go. The hospital wouldn't allow visitors. The nurses were angels that night. They were everything you could hope for in a human image of God, and the doctors in Brunswick were just as divine. Thomas and I drove home that night. We prayed, we talked, and we played songs Austin loved. He loved country music. We slowly came to realize that things in our world were never going to be the same again. The next day, our nightmare really began. I had personally written my phone number on the transfer orders in the ER and asked for the people at the hospital in Jacksonville to call me when he arrived, and they had him under observation. We barely slept that night, and as of 7 a.m., we had not heard anything from the hospital. I called 3 or 4 times and still nothing. We didn't even know if he was alive. We finally heard from somebody in the hospital right after lunch the next day, and they scheduled a call with the neurologist. The neurologist called and gave us the worst news ever. Austin's brain had suffered under over 100 strokes. And the cardiac arrest caused him to be unconscious for too long. We had to make a decision no parent should have to make. Our Austin was not a drug addict. He was a lovable guy who loved to cook, fish, hunt. He loved people. He had a fantastic job and a bright future. He took an occasional Xanax because he suffered from depression. Unfortunately, he bought him off the street, always from the same guy. We're sure that he was just too ashamed to ask for help, like so many other people. It's been 28 months since Beth and I lost Austin, and as a family, we're trying to find a new normal. I read something the other day that best describes this grief journey. The death is a date on the calendar. Grief is the calendar. It's been hell, but God has never left us. We both feel that Georgia needs additional laws in place to curtail this rampant distribution of fentanyl and other dangerous drugs. This is an excerpt from one of the other emails I sent to Russ. I said, Russ, I know you're very busy. I know that you're passionate about the important things in life. I also know that being a farmer, life is like a crapshoot when it comes to bringing in a crop to full harvest, much less maintain the farm the rest of the year. I'm here to tell you that our children's lives shouldn't be a crapshoot. We have the ability to put laws in place that severely punish people for selling drugs that are laced with deadly drugs that cause the death of an individual. I don't want anybody to be a part of this club that we're in. I can promise you there is nothing worse than losing a child, especially senselessly. Please, let's put something in place to punish these people to the same extent that we feel punished. Thank you for your time.
Thank you, Mr. Walters, and Mrs. Walters as well. Thank you again for being willing to share him with us and share your story with us. Do you have anything else?
Yeah, Mr. Chairman, if you don't mind, as you know, this bill has been drafted in conjunction. This is the Lieutenant Governor's bill, and I'm not an attorney. I know you. Here I
told you
said
not
it.
to say that.
I know. I
told
did.
you not to say that.
But I do have a phone a friend. But I have Jack
That either.
Winnie with me,
Yeah.
and Jack is the Chief Assistant District Attorney in the Coweta Circuit. And he has been involved in this process of drafting this legislation as well. And so when it comes to, I'm sure we have a committee full of lawyers on here that I would be woefully inadequate probably to answer some of these questions. I would like Jack to help me with that.
And do you want to add anything before we take questions, or?
Whatever the committee's pleasure is, I can kind of walk through it, or I can just take questions.
Okay, let's start by we have also Ms. Maisie Lynn Girton's going to testify as well, but let's do with questions right now for the author and for Mr. Winnie about the bill. Senator Cowsert.
Y'all's story is heart-wrenching. A very almost identical thing happened in Athens this fall with a young fraternity boy in Athens who was the nephew of some close friends of mine, and it was Xanax, and it was laced with fentanyl, and they figured it out because he only took a half. And I think it was given to him, though, by another fraternity brother for similar reasons, but in Athens they take Xanax to enhance the effects of alcohol as well. But totally devastated that family, just as you have been. Jack, my concern about this is I've never ever seen a criminal statute that didn't have some mens rea, some intent, and this very specifically says even if the person selling the drugs, given, like in that case, this fraternity brother that gave him the Xanax would be in jail for 10 to 30 years and never knew it was even an illegal substance. I wonder where that came from, and are there other parallels in the law, or doesn't there need to be at least negligence or carelessness?
Sure. So, a couple things about that, Mr. Chairman. The knowledge subsection comes from in response to some appellate decisions. There's a line of cases that have interpreted 161330, just possession and distribution, to require knowledge of the chemical identity of the substance. And particularly with fentanyl, fentanyl is not being sold as fentanyl, it's not being bought as fentanyl, and the vast majority of the time the drug dealer knows he's selling a drug and may not himself know that he's selling heroin laced with fentanyl or a counterfeit oxycodone that just has fentanyl. And so there's kind of, because of that requirement currently that the state has to prove knowledge of the chemical identity, that's what it addresses. The statute itself, the operative language, is modeled after the felony involuntary manslaughter. Mm-hmm. So it's through selling, distributing, delivering, and so you would have to intentionally do that, and that would have to approximately cause the death. But the knowledge is as to the chemical identity of the substance. And again, most of the time, fentanyl is not being sold as fentanyl, and even when the dealers know that what they're selling is laced with fentanyl, proving that is a whole nother issue. And so that's what the target is. That's what that language is for.
Okay.
And did that answer your question? Did you?
Yeah, it does. I've just not seen that. I wondered if there wasn't a way to say, negligently failed to ascertain the contents of it, or it's reckless. If you're selling something that you don't know what it is, well, then this can happen. But I wondered if there was another way to phrase it. This says without any intention to do so, without knowledge. I would love it if it was more like without, prudently trying to ascertain what was in it, or something like that. I can't suggest to you.
And to be clear, so the without any intention to do so, that's from the involuntary manslaughter statute that's already on the books, and that goes to causing the death. And this would also cover, when a heroin dealer sells heroin that's just heroin and kills someone, even knowing that it's heroin, the state just wouldn't have to prove knowledge of the chemical identity. And the majority of deaths come from fentanyl-laced drugs. I think we all understand that. And a lot of the times the dealer may know or may not know, but that's in there to address that kind of hole, by the requirement that the state prove knowledge of the chemical identity of. I think you'd still would have to be knowingly and intentionally, manufacturing, delivering, distributing, or selling any controlled substance, counterfeit substance, or imitation controlled substance. It's just clarifying that the state doesn't have to prove knowledge of the chemical identity.
Okay.
Senator Parent.
Thank you, Mr. Chairman. Thank you so much, and I'm so sorry about your son is very handsome. I can only imagine what a terrible loss it is for your family, and thank you for being willing to come up here and share, and thank you, of course, to my wonderful colleague for bringing this forward for our consideration. I just had a couple questions about the way we would treat such a thing now. So, obviously, there are penalties now for selling illegal drugs.
Yes.
Can you explain what that crime currently is to me and how it works?
Sure. So selling, it depends what schedule the controlled substance is in, but 161330B deals with selling, distributing, possessing with intent to distribute, et cetera, controlled substances. A first offense for that is 5 to 30 years, and a second or subsequent conviction for that is 10 to 40 years or life.
10 to what?
10 to 40 or
40.
life.
Okay.
It for schedules, I think it's 4 and 5. It may be 3, 4, and 5. Schedule 3 is kind of rare, that's a 1 to 10. So Xanax, for instance, is in Schedule 4, and selling Xanax would be 1 to 10 years.
Okay, thank you. And so in this, you have 10 to 30. What are the current penalties for regular involuntary manslaughter? Because is this a new crime?
This would be
aggravated involuntary?
a new offense, and so there are two different kinds of involuntary manslaughter currently. The one variety of it is a misdemeanor. The other, that's I think a lot more common, felony involuntary manslaughter, is basically, it's like felony murder, but it's when you cause a death through the commission of a misdemeanor, and that is punishable by 1 to 10 years. So this, and then, obviously felony murder exists, and so, theoretically and in practice, this conduct is prosecuted as felony murder, which has a mandatory minimum life sentence and those cases are being prosecuted, but this bill gives a range of anywhere from 10 years of probation up to life in prison in the discretion of the sentencing court, as opposed to just life. And 2, it removes obstacles to prosecuting and holding dealers accountable that are present in felony murder cases, like proving the knowledge of the chemical identity of the controlled substance.
Thank you.
Any other questions from the committee? All right, if you want to step aside for a second, we'll have Ms. Maisie Lynn Girton from Gactyl. Good evening.
Thank you for hearing from us on this issue. I'm Maisie Lynn Girton, the Executive Director at the Georgia Association of Criminal Defense Lawyers. And I would like to say at the outset, I am also a mother of children who hear this story and think it is very important to remember that there are people like Austin dying in our state and across the country from all sorts of problematic drugs. And there is nothing about my concerns in this bill that are meant to at all diminish the grief and pain of this family. But as you all know, the means and methods that are adopted by this body go on to affect many thousands of people from here. And so in hopes of helping you do that in a way that can potentially satisfy the concerns of the exact scenario that was laid out that happened in Austin's life, I have a couple of recommendations for you about this legislation as you're considering it today. I have similar concerns to what Chairman Calzert has mentioned regarding the intentionality or lack of intentionality required by this code section that I'll address second. But the piece that I am most concerned about is at line 23, and I'm working from LC 49-1806S. I hope that is where you guys are.
That's the sub, that's right.
Two of the mechanisms by which the drugs at issue in this bill could be shared are precisely what Chairman Calzert mentioned, delivering or distributing. It also includes on line 22 manufacturing and on 23 selling, which is what happened in Austin's case. My concern is not about manufacturing or about selling, but it certainly is around delivering and distributing. If we go back and look at 161330, which if you notice above in lines 15 through 20, there are several definitions pulled from Title 16, Chapter 13, which is also where 161330, the underlying drug possession and sale crime rests. But there are definitions for delivering and distributing also in that section. For instance, when we are talking about a controlled substance, there is a particular definition of deliver or delivery that means the actual constructive or attempted transfer from one person to another, whether or not there's an agency relationship. Distribute can be any delivery of a controlled substance other than administering or dispensing it, as we might consider a pharmacist to do. But then also in Chapter 13, there are definitions of deliver, delivery, distribute that would hearken to how those words are used in the ordinary course of business and the meaning that we prescribe to them in the ordinary course of business. So there are a variety of ways our law considers these notions of delivery and distributing, and each of them captures these exchanges of, in this case, drugs between individuals, let's say at a fraternity party, at a high school party, at any kind of situation like that where you might imagine, as much as we don't want to, our children potentially sharing illegal or counterfeit or imitation controlled substances with one another. So our concern with having those two mechanisms of delivery and distributing contained in this bill, it takes it out of, takes us farther away from the people who I believe we are often most concerned about, sort of the true dealers and distributors and sellers, and pulls us into this place where you have a greater risk of unintentional consequences for grabbing up teenagers, or really anyone of any age who's sharing kind of in this recreational sense drugs with one another. My suggestion would simply be to remove those two words from the statute. That would allow still the statute to apply to the sale of these substances to individuals and still capture the scenario that you all have heard today without the concerns raised by Chairman Calzert also being included. I have just also been in another hearing today on another bill wherein there is a policy under consideration that would codify felony murder predicated on the 16-13-30 when fentanyl is involved. And in that hearing, a representative from the Prosecuting Attorney's Council said what I'm getting ready to say to you too, and that is today in our state, prosecutors can prosecute felony murder when these situations occur. One of the potential unintended consequences of this bill, and I certainly would defer to legislative counsel and to my learned colleagues across my courtroom aisle, is the rule of lenity. When you have a crime with a lesser penalty, the lesser penalty is going to prevail over the more serious penalty with the rule of lenity applying. It's not really in my best interest to be letting you all know that, but I would like to think that you understand that we try to operate in good faith here, and if I didn't let you know that, to at least consider it, I wouldn't feel like I was holding up my part of the bargain of educating you on the concerns and things we see about this legislation. This lack of intentionality certainly does give me less pause if you were to remove the delivering and distributing aspect of it. With it included, it is devastating to think about a situation where someone who potentially routinely does purchase from a safe source drugs that have helped them support their lives, whether or not we agree with that happening or not, and then potentially sharing that with a friend, that's where we lose with the delivery and distributing aspect of this bill. And I would stand for any questions you have.
Any questions for Ms. Girton? All right. Thank you.
The time.
Anything else, Mr. Winnie? Come on up. Will you address the rule of lenity issue that was raised as well?
Yes, Mr. Chairman. So a couple things about that. I think number one, this bill is punishable by life imprisonment, and so that's part of the idea is, while this is currently can be theoretically prosecuted as felony murder, the same conduct, this gives a broader range, which but includes life imprisonment. There's also the statutory non-merger provision at lines 28 and 29, which I think typically
Does that defeat the rule of lenity, the non-merger language?
typically I think it does, but because it's also punishable by life imprisonment like murder is, I think that also sort of deals with that. I would also point out, Mr. Chairman, so first with the delivery and distribution, there's a couple things with that. One, those are violations of 161330B right now, and thus could be prosecuted as felony murder. So theoretically, this hypothetical we're talking about, could be prosecuted as felony murder, where there's a mandatory minimum life in prison sentence. This gives sentencing courts for situations like that, if the case is charged by the district attorney in the first place, as opposed to just having life in prison, gives the sentencing court anywhere from it's 10 years, which could be probated or suspended theoretically, up to 30 years or life. And the delivery and distribution, is currently covered as a violation of 161330. B. The other issue with delivery and distribution is, oftentimes drug dealers will distribute drugs to someone who they sell to on other occasions, but maybe on the particular transaction that results in their death, they didn't necessarily sell it; they just distributed it, and with the idea that the purchaser would pay them the next time. And so I think that's one reason it's important that distribution stays in there. And again, with there's not the lack of intent. There's no intent to kill, just like in the involuntary manslaughter and in felony murder. I think you have to intentionally do these acts that constitute selling, distributing, delivering, manufacturing the substance. It's just without the intent to kill, which is also in involuntary manslaughter, and the knowledge of the chemical identity is the only difference. All right.
Any other questions from the committee? Senator Parent.
Thank you, Mr. Chairman. So in the example from Senator Kauser, that fraternity brother could be charged under this, but it could be probated or suspended.
Right, or not brought at all, but yes.
Well, right,
but yes.
Say they're like, well, we really want to show these kids that they're messing.
That could be a suspended or probated sentence under the language that is in front of this committee.
Thank you.
Senator Hatchett.
Thank you, Mr. Chairman. I was wondering, the drugs that are included in this are the Schedule 1 through 5?
Yes,
drugs.
Those are the controlled substances, and then there's the Controlled Substances Act also has definitions of counterfeit and imitation controlled substances.
So is alcohol included in those controlled substances?
No, alcohol is not a controlled substance.
Okay. What are some more common controlled substances that may be included in that list?
I mean, so controlled substances are the crimes that it's a felony to possess unlawfully. There's also dangerous drugs, and there's other drugs that aren't dangerous drugs or controlled substances, but any sort of street drug and then a whole lot of other prescription drugs are going to be a controlled substance. But those are what schedule they're in and whether they're a controlled substance. I think that's something the General Assembly deals with each year when there are sometimes changes and new drugs. But anything that's on the street or a serious prescription medication is a controlled substance, generally speaking.
So, if I may, Mr. Chairman, so doesn't necessarily the substances that are included it doesn't necessarily need to be laced with anything, but just a Xanax, if it was combined with, like, if you took a couple of Xanaxes and then went and drank alcohol and you were to overdose, would that fall under this?
That could potentially, there would be potentially a causation issue with that, because Xanax isn't lethal in and of it. You know, I mean, that it would depend on the facts and circumstances of the case, but Xanax is a Schedule 4 controlled substance and would be theoretically covered by this, as it is also, you know, under certain circumstances, you know, could constitute felony murder.
Okay.
Senator Watson.
Mike 15, just clarification. So Schedule 1 is what you had mentioned earlier, just for the committee. You know, heroin, LSD. Marijuana is still a Schedule 1 drug. Schedule 2, the oxycodone, the heavy-duty, you know, narcotics, morphine. Of course, Schedule 1 is not legal, even though some states marijuana is. And then, like you said, Adderall is a Schedule 2 drug, though it's generally not lethal, but because it was abused in the 70s, it was changed into that. But I'll disagree with you on the Xanax and alcohol. I mean, that's a lethal combination. I mean, and that can be one or two Xanax and a good bit of alcohol, which is not an unusual thing at a party that occurs, especially young ages that their frontal lobes are not well developed. That can be lethal, and there are court cases that go back. I'm no lawyer, physician, but I mean that's the Karen Ann Quinlan case. That was alcohol and Valium. I think she did have some phenobarb on board too, and was the brain death case that was the Supreme Court.
So, to be clear, what I meant to point out was, if the alcohol wasn't attributable to the defendant who sold the Xanax, that could be a causation issue.
It could be, and
what I was saying.
Listen, I've had patients that I've put on a ventilator because of pure alcohol, and St. Patrick's Day, alcohol poisoning on a ventilator overnight in ICU and discharged from the ICU. That's terrible situation, but you add a little bit of Valium or alprazolam, Xanax, then that's going to be a lot longer and probably more lethal and quicker. So I would think that plain Xanax would be a contributing factor, or could be under this statute, I would think.
Yes, I mean, it would be covered by this, and all I was saying was there could be a causation issue, because if it was because of being combined with alcohol, and the alcohol couldn't be attributed to the defendant, it may be, it may not be.
All right. No one else has questions. I apologize. I did miss one person who wanted to be heard. Jeff Breedlove, if you want to come up real quick. Mr. Breedlove, apologize for missing you.
Jeff Breedlove, here for the Georgia Council for Recovery. I'm a person in long-term recovery, and thank you, Mr. Chairman, for allowing me a few minutes. First of all, may your son's memory be a blessing. And thank you to the chairman for bringing the bill and the lieutenant governor for bringing the bill. I'm a survivor, and there's about 900,000 survivors in the state of Georgia of the disease you're talking about. And I'm not a lawyer, so I'm a little bit intimidated. So I thought maybe I'd bring the non-lawyer voice before you adjourned on this particular bill. I get lost in all the code sections. Somebody's got to go to jail. That's what I know. Somebody's got to go to jail. But what I hope as you deliberate and work on a piece of legislation that does impact thousands and thousands of people once it becomes a law, don't send the wrong people to jail. There's a disease at the core of this. I was a drug addict for 30 years. I was sick as you could be. And I got brothers and sisters out there right now on the streets that we could walk from this capital to. And some of them look like me. And they'll take $10 or $1,000 and they'll buy some drugs. I'm buying them from people who aren't the bad guy you're after. I don't deal with them. I'm buying them from somebody else who's had my disease. They may look like me or they may not look like me, but they're a person in active addiction. It may be my friend at a party at our flagship university. I just beg you all, and all these judges in the room, I couldn't miss this opportunity. Just please work on the language so that when a person encounters law enforcement and they go through the process, that there's stopgaps in there for judges and DAs to have discretion and use their discernment to know who do we need to send away and who do we need to get medical help from. And that's also a responsibility of the state, is to get the right people help. That's all I wanted to say. I appreciate this bill. I appreciate what this bill means. Please just make sure as you work on it that you prosecute the right people and do not have unattended consequences of taking somebody with a disease who is not a bad guy and classifying them the wrong way. That's, Mr. Chairman, that's all I wanted to say.
All right. Thank you, Mr. Breedlove. Any questions for him? All right. Thank you.
Thank you, sir.
I do want to commend the author as well. And we have to look at every circumstance is different. And I think it's important that when you look at bills like this, that you do have discretion for courts and discretion for those judges to look at case by case. And that's included in this bill. So I know you have different levels of protection from the case the prosecutor brings and their discretion. You also have the discretion of the court as well built into that. So I just appreciate y'all being so willing to work to continue to address any unintended consequences that could ever come with legislation like this. So no one else is signed to speak on the bill. What's the pleasure of the committee? We have motion to pass by committee substitute from Senator Rhett. Is there a second? Do we have a second?
Yeah.
Point of order?
Point of order, yeah, point of order. It seems like, I think there's just some questions around the intent, and I would like to write down what I need to look myself at what our witness gave me in terms of current crimes and how they fit in with the sentencing before I feel comfortable. I wonder if the author would be amenable to letting us keep it for a...
I can answer that for him. We always say we run out of time. We do have time. We'll have 2 more hearings next week, and so I'm going to present a bill in a minute. I'm going to ask y'all to do the same thing on probably. So it's okay to, if that's the pleasure of the committee, to let us keep looking at the bill. Senator Calzert.
I'd like to offer to work with Senator Goodman. And, of course, I know Jack Wynn well. He's a dynamite prosecutor. This is a problem we have to address. We got to figure out how to stop it. And it's going to take harsher penalties for people not being way more careful with these things. And I'd like to offer my help, but I do think we can probably massage this a little bit and get it. I don't think we accomplish anything if we pass a bill that's going to be found unconstitutional soon, and I fear that. And I'd love to talk with Senator Jones as well as an ex-prosecutor to make sure we accomplish what we're trying to do without going too hardcore. So I'd offer my assistance, and I don't want this committee to vote this bill down. I want us to keep it alive so we can try to massage it.
And absolutely, I welcome the input of any of our attorneys to help this. But I would just say this: since we filed this bill and dropped it, I have gotten more calls from people that I had no idea had never been affected by this. And I suspect in the future, when we do get this bill to where people are comfortable with it, you're going to be amazed that we're going to have more people coming up here testifying. This is a real issue. And y'all know that I'm certainly not a criminal defense attorney. You know, if you want to talk about growing blueberries, we can talk about that. But you know, when I look at what we see with our friends and neighbors, what's happening right now is not working, and we've got to figure out a way to have a greater deterrence Because if we don't, people are going to continue to die. People are going to continue to die anyway, but my hope and prayer is that we can lower the amount of people that are dying. And so I just ask for y'all's help in that.
Senator Hatchett.
I just want to say to the author, I mean, my good friend, Russ, I want to help work with you on this bill, and to the family. I mean, I can't imagine what you're going through. He looks a lot like my brother, and about the same age too. But I think, I'm 100% behind the intent of the bill. I think there's some language issues that we need to craft, and would really like to get something that we can work on and pass to honor his legacy. And thank you for sharing your testimony today. It was brave to be here, and y'all are doing a good job honoring him.
Senator Kennedy.
Thank you, Mr. Chairman. I too wanted to thank the author and 100% agree something needs to be done. And thank the family for coming here. I promise you the impact you've made by being here and sharing your story is more than you know. But as Chairman Cowsert said, sometimes, and what I really wanted to say was, please don't take the reticence of action on this specific bill as any indifference from this committee or a lack of a desire to do something. It is really to make sure that what we do is truly enforceable, and that your objectives, as well as the public policy objectives of, I think, everyone on this committee and the legislature, are appropriately met as soon as possible. Sometimes we move too quickly, and the courts tell us 2, 3, 4 years down the road that we moved too quickly and we were too broad, and now you've got 2 or 3, 4 years of prosecutions that get undone, and that can be incredibly painful on the families that are in the position y'all are in. So please don't take the inaction. It's just we want to get it done right, especially if something as important as what y'all have shared with us, and thank you for that. And I thank Chairman Goodman again.
Yeah, and I welcome the help. So
Yeah, more love from
And
the
I too
committee.
want to help in that.
Senator Rhett.
Elvis, we're going to help you find your freedom on Blueberry Hill with this bill.
Thank you, my friend.
Well, it's my desire that we try to get this done sooner than later. We don't have to have a full-blown hearing again if we can work on a substitute. You've heard the desire of the committee, so let's come together and get a substitute next week that we can get out so we can keep this bill moving forward. That would be my desire.
Thank you, Mr.
Thank
Chairman.
you.
Thank you, members of the committee. Thank you.
All right. The next two bills on the agenda are my bills, so I'm going to pause for just a minute. Let's take a 2-minute break, and we'll let Senator Cowsert come up, and I will go down and present these bills.
Amanda Farahani, you can sit up here if you want to. Yeah, you can sit with him. All right, we've got quite a few still in the crowd, but we've got several bills left to get through. The first one on our agenda was Senate Bill 425. Blake Tillery is carrying that bill. He is stuck in our appropriations process right now and has told us he's not going to be able to make it. So he could make it, but we're going to be gone. But I hope, Mr. Chairman, before he gets here. So, he'll have to come back on that one. So we'll now hear Senate Bill 283. Senator Strickland.
Thank you, Mr. Chairman, members of the committee. I am a lawyer, but I'm not an employment lawyer, so I brought my lifeline, Ms. Amanda Farahani, here with me as well to answer any questions and walk through part of this bill. I mentioned earlier, you file a bill. I filed this over almost a year ago, and I did it kind of late in session last year because I knew this was complex. It was also at the time a federal bill being debated in Congress, and I wanted to have a year to get feedback. And as this process works, you have to put a bill on for agenda sometimes to get feedback. And so I've got a lot of feedback this afternoon in particular about the bill, and there's no one that's reached out to me yet that gave me concerns that I said, well, I have the same concern, I want to fix that. And so I'm going to ask you to give me a chance to work on this, have a hearing tonight, and I'd love to hear everyone testify about this and let me work on some changes, hopefully bring back another substitute next week. It's the Pregnancy Protection Act, we call it. Let me tell you where this bill is coming from. When I was first elected, I was a single guy. I didn't have any kids yet, and I had a little different perspective of life. Now, as others can relate to, when you have kids, you think of things differently in a lot of different ways. But for me, in particular, having our two boys over the last 6 years, for me, my wife working full time as well, I may lose a little sleep. I may take a little time off to catch up from that. I may look more tired than I already look. Maybe a little shorter temper because of all the stress. But pregnancy, being pregnant, and obviously having the child affects men and women differently. We all know that. But I have gotten to now personally see how it affects you in the workforce differently. I can go back and go about my job. And again, I actually did a jury trial, a 2-week jury trial, longest in my career, right after my first son was born. Again, I was just extra tired. But for a lady that is wanting to have children, going through a pregnancy and having a child, we're in two different worlds. What this bill is trying to accomplish is to try to, in a way that fits Georgia and our values and how we balance things in the state, to have some guidelines in place that says this is how the workplace is going to work for expectant, potential, and new mothers in our state. Also, being pro-life, I'm proud to say I'm pro-life, but it's beyond just protecting the baby. I think it also includes protecting the mother. And I think this bill, Senate Bill 283, will go a long way, again, in setting some standards in our state as to how mothers are treated by businesses in our state and the workplace, and help balance some of the inequities that we've seen forever and will always see in different places, help balance some of that out in our state. So what the bill actually does, diving into it, the first section, which is very important, is just the definitions that will be used, looking at the type of employee that will be covered, the employer that will be covered. This would include pretty much every employer in our state that has 10 or more employees. It would include every type of employee in our state. It's not limited to a particular type of employee, someone that provides services to an employer. You look at lines 30 through 37, it's very important. We'll go back to this. It defines what reasonable accommodations are, and it gives some examples of what that would be. Moving into the bill, you really have two different civil causes of actions that are built into this bill. The goal is no lawsuits ever filed. And I'm going to ask my friend when she speaks to reference what happens in other states when you have laws like this. Reference what's happening at the national level. You've had a law in place since, I believe, last summer. The goal is not litigation. The goal is that we set standards where there won't be litigation in our state. But to do that, you have two causes of action built into the bill. The first section, lines 40 through 63, deals with the cause of action for pregnancy discrimination. And you can read it for yourself. I won't read it to you, but it gives different elements that someone would have to meet if they had one of these claims. And it comes down to this. For the employer, they would have to show, as we're going to get to in just a minute, that they couldn't make these reasonable accommodations as defined in the bill because of undue hardship. I have purposely worked on this bill to be broad, to not say this is how it should work in every single business in our state, because every single business is different. A business with 10 employees is different than a business that has 1,000 employees. You can adapt the changes, you can deal with things differently. Every employee is different. The service they provide is different. Not every company can make accommodations. That's why you have the defense of the undue hardship built in. And so we try to capture that with the definition that we have here as well. Getting in the line 64 through 74, this is the notice that would go to all employees, existing employees, new employees, and also someone that notifies their employer they are pregnant when it comes to their rights under Georgia law. Undue hardship, I mentioned, the employer provisions are lines 75 through 84. That says this is what an employer would have to show to say the undue hardship of making these accommodations does not work for us. Therefore, we don't have to make those accommodations by law. And then you get down to the second cause of action built into the bill, and that's the cause of action for retaliation. Retaliation for reporting someone that is not in compliance with this bill. And you'll see that cause of actions 85 through 96 in the bill. Two other things, the statute of limitations. We went with what's current law for torts in our state of 2 years from date of the violation. You'll see that in lines 97 through 102. That's when you could actually bring one of these claims. One of the two types of claims again, a pregnancy discrimination claim or a retaliation claim. And lastly, you see the clause that talks about the damages that someone could seek in one of these claims, 103 through 111. And I shouldn't say lastly, you also see we have a general line that says that this bill is not meant to preempt or limit or diminish any other protections provided by law. And that's the lawyer side of it. I go back to where I started. My goal with this bill is to strike the right balance in our Georgia law so we can have Georgia law in our courts and not rely upon the federal process for these kind of claims, and to set a standard in our state where there'll be no more lawsuits. It won't be necessary because we all can agree and come together and say, this is the standard. This is how we're going to treat women. This is how we're going to treat mothers, prospective mothers in our state. And this is how we're going to support families in our state while still being the #1 state in which to do business. And so with that, Mr. Chairman, I'm happy to answer questions or pass it off to Ms. Amanda as well.
All right. Are there any questions from committee members for the author? Then let's hear from Ms. Amanda.
Thank you, and thank you for the opportunity to be heard on this important bill. My name is Amanda Farahani, and I'm an employment rights attorney. I'm the managing partner of Baird & Farahani, which is the law firm headquartered here in Atlanta that does employment civil rights. This bill is an important bill that you should pass because the Pregnancy Protection Act will provide protection for the health of unborn children and their mothers. And it will allow for women to continue to work and thrive in and for Georgia businesses. Women each day are losing their jobs and being forced to find ways to support having their children, often without health insurance. And the harms go even further. Many pregnant women who lose their jobs are facing evictions or temporary homelessness. They have their cars repossessed, all of this leading to lower credit ratings, which creates a cycle of higher financial burdens and charges and the inability to take care of themselves and their family. Passing this law would change that. This law provides the woman who wants to work the ability to work. And this law is also good for Georgia businesses and for workforce development. By ensuring fair treatment during pregnancy, Georgia's women can better contribute to the workforce and to society. Georgia could add 9% to the state GDP by 2025 through policies that help increase the number of working women in the state, with Georgia currently ranking 30th for female labor force participation. If Georgia doesn't protect pregnant workers, it is risking losing some of the state's best workers and brightest minds. In addition, fair and supportive workplace policies can enhance employee morale and promote a positive image for the workplace. The cost of employee turnover for businesses, one of the major drains on a company, will be greatly reduced. And the good news about this bill is that the accommodations that are being requested under this, the Job Accommodations Network has said, cost most employers either $0 or less than $300. Passing this law also reorients its businesses to think about the unborn child. We're providing a simple accommodation like a chair or time off for a doctor's appointment could mean the difference between life or death. Georgia has the third highest infant mortality rate in the nation, and 11.4% of babies are born preterm, making it even more important that Georgia go further than any current federal protections. One of the major strengths of this bill over the current federal law is that federal laws require employees to bring a claim with the EEOC within 180 days of their discrimination, and that's usually while women are pregnant. And they need to be focusing on taking care of themselves and the health of their child instead of making the decisions about pursuing a bureaucracy at the time of their pregnancy. Now, some may say that passing this bill will cause a rise in litigation, because any law is going to cause a rise in litigation. But we would be the 31st state to pass pregnancy accommodation bill, and there has not been a corresponding rise in litigation in any of those other states. Georgia itself passed a bill last year, a year and a half ago now, for sexual harassment retaliation, and there have been 0 lawsuits filed in Georgia under that new law. And Congress passed a law last year, the Pregnancy Workers Fairness Act, that has some of the same protections as here. And under that law, nationwide, there have been 232 lawsuits that have filed. That means extrapolated less than 10 new lawsuits per state per year. So there isn't going to be a rise in litigation. Instead, as the U.S. Chamber of Commerce said when looking at the law in Congress, this law provides clarities to employers about what to do in the workplace and how to protect pregnant workers. Nearly 1 in 4 fathers report that their spouse or partner has experienced pregnancy discrimination. And in this post-Dobbs era, protecting pregnant mothers and their unborn children must be a priority for Georgia. This law will be a positive step forward in that protection. Thank you for giving me the time to address this important legislation, and I'm happy to answer any questions that you have about either this or the federal laws.
I think Senator Watson may have a question.
Well, I mean, that was it mostly, comparing, contrasting federal versus state. So, I mean, I think you answered that mostly with the EEOC. That's 180, and then the 180 days.
Correct. Yes.
Okay.
So the federal law requires 180 days to go to the EEOC, and this provides a 2-year statute of limitations. So
Okay.
women are able to have their pregnancy and then deal with this at it.
And the federal law that was passed, you said a year or 2 ago?
Yes.
And that is law, and you said maybe 10 cases per state kind of thing?
Exactly,
federal.
10 cases.
Okay. I mean, I got it. Thank you.
Senator Kennedy.
Thank you, Mr. Chairman. Good afternoon, Amanda. Good to see you.
Good to see you.
And I want to thank Chairman Strickland for the way you began this and unpacking this to let us know sort of your approach to this. And you have a real talent for complicated and delicate things and putting them in a way that's very understandable. And you did here, and I appreciate that, the motivation behind why we need to have something. And so I think that premise I agree with. But I do have a couple of questions that either from experience or just some general questions about maybe why we've got the model set up the way it is. Excuse me. One, I noticed that the definition of employee is not just the traditional W-2 type worker. So I have to default then and think, so is this independent contractors? Are these job applicants? Is this everyone? And I think this would apply to everyone, and I'm wondering what is the thinking behind that, because what that makes me wonder about is that traditional divergence between employees and the duties that employers owe to employees has a baked-in assumption of control of the environment for the employee, and the independent contractors on the other end of the spectrum from that. And so then I start trying to unpack, well, how does the employer then, should they be responsible for all circumstances when they find they're in an environment that they don't have that level of control? So can you speak to that, on what the thought was behind having it apply so broadly?
Let me give you my take, and then Amanda may have a different take from her perspective. For me, I erred on the side of being broad with it, and if that's something that's one issue I've gotten feedback on the last several hours. If that's something the committee wants to tailor down, obviously we could look at doing that. One of the things that we've dealt with in the legislature, there was a Senate study committee on this a few years ago, is misclassification of workers. And so for me, there's some concern that it could lead to more workers being misclassified potentially, or erring on the side of not having W-2 employees. I don't know if it would actually happen in practice, but that was one concern I have. But it is broad. The way it's written, it would be any individual who provides services, as it says, for salary or wages or other I was going to say consideration, legal term, but remuneration, as it says here. And so I was erring on the side of, if you have someone working for you providing some sort of service and they request these accommodations, I was trying to make it where the same standard be in effect there versus having just it with W-2 employees. The one difference would be the notice provision. In there, when it comes to especially the posting of the notice, that's going to be more for your W-2 employees, of course, I would think in most situations. But I'd be open to suggestions in the committee on that. Do you want to add anything?
Yeah, the definition of this actually tracks some of the Georgia code that already is in place. So there's two parts in Chapter 30 or Title 34 that deal with the definition of employee. One of them actually is an individual who works for an employer for salary, wages, or remuneration. So that's under 34.110 and is already a definition in the Georgia code. The other part where it's talking about providing services is not a generalization, but it's a summary of the unemployment law's definition of employee. So although it's different than federal law, which has defined it very much like a W-2 employee, Georgia law, when it does apply to employees in the context of unemployment or paid leave or the other kinds of things that are in place, does use this definition. So it's not any broader than Georgia, it's just broader than what the federal W-2 statute is.
Okay.
That makes sense.
You need to follow?
Go
right
just,
ahead.
Yeah,
Sure.
thank you. Amanda, do I understand that covered employees under federal law typically begin at entities that have 15 or more employees? But I think,
correct.
Do I understand this one's at 10?
That's right.
What would be the difference in why 10 versus 15? And again, I'm not suggesting that this needs to follow the federal law, but that's sort of the model I have some familiarity with. And
Right.
so I think of it in those terms. So why the divergence?
I believe the bill started with 4 employees, and that's what most other states that have been passing state laws start out as 4 employees. It varies per state, but that was a negotiated number with the chamber when we were talking about the workplace harassment bill, was at 10 employees.
Okay.
Yeah, the original draft was 4 that I filed a year ago. So we were not trying to track the federal definition at that time. It was more of a model of other states. But again, we've moved up to 10, but if the committee is wanting to track the federal, then you could go to 15.
Okay. And then I think this was in part in what you addressed in your comments, but the traditional EEOC route that employees who have grievances follow, with the 180 days, and then you get your right to sue letter. This would allow a direct, immediate filing of a lawsuit. So help me understand the difference, that other model, again, just familiarity, not saying it's perfect or even should be the right one, but help me understand the thought of making this different given how long we've had that model and how many claimants have used that for a long time.
Yes. I would say just because it's been around a long time doesn't mean that it's right. It's a bureaucracy.
I'd agree with that. Yeah, sure.
And it's a bureaucracy that has lost its relevance. So it's a government-funded agency that's been around for a long time. It does not provide really any benefit to employers or employees, and really just creates an additional hurdle that I don't think benefits either employer or employees. So in other states, there are not the requirement. There are some administrative agencies that have been created by other states, but there's not that requirement to go through that route. It's an opportunity or an option to do so. This does not create that additional bureaucracy in Georgia.
Okay.
Can I add one other thing on that? Also, 2 points. One, the federal model, to me, and I'm not sure if the numbers show this as you're saying, but encourage you to go ahead and just send something because you have a short window and you immediately make your claim. My hope is with this, you don't have such a shot clock that you're just going to have people just throwing claims up. Second, you do a lot more federal work probably than I do. I do some federal work in federal court too, but I like that these claims can go into Georgia courts, our superior courts in our state, versus going through the federal court process. These are, maybe a little biased as a state legislator too, these are our courts. These are your superior courthouses in your towns where if a claim is made, these things are going, and not to the big federal courthouse in Atlanta, I guess Savannah, Macon, Brunswick. Nothing against Macon.
Macon.
Macon. And so I also like the idea of doing it, as I said, a Georgia way, but something where our judges, our courts will be handling if there is a suit too.
Okay. One last question. Just
Fire away.
was there any discussion given to whether or not there would be any caps to any form of damages, like of course we have under the federal model or any other model? I'm reading this that these are totally uncapped and unlimited, both in compensatory and punitives.
There was not, but there is a push at the federal level to eliminate the caps right now because they don't tie into the profitability of a company. They're based on the size of an employer. And since 1964 or 1991, when that was added in, companies have changed. And so tying the cost to the size of the employer doesn't really make a lot of sense when an employer is making $1 billion and has 100 employees and can choose not to accommodate a pregnancy. $50,000 doesn't make sense as a reason for them to be incentivized to not do it.
Okay. Thank you, Mr. Chairman, and thank you for this discussion. It's
Thank you.
helpful.
Senator Watson.
Is that the cap at 50? I thought the cap was more.
It's up to 100 employees. It's $50,000.
And higher?
The highest is over 500 employees, and it's $300,000. That was put in place in 1991.
Yeah. So, I mean, in essence, it sounds like if we don't go along with the federal using caps, then it sounds like we would see more in the state system than we would in the federal system.
If there was an opportunity for one or the other, that might be so. But my hope with a law like this would be that what it would do is provide employers a clear path to ensure that they can take the steps to prevent any kind of lawsuits.
Of course, we could use higher caps too, for that matter, or different caps.
Right, or not tied to the
would
size
the
of the
author be
employer.
receptive to caps?
So I'm not that familiar with, in Georgia law, there are places we use caps, unless I'm missing something. I'm just not, it's not my world of, because my challenge with a cap to me is what she said, is business could make a decision to purposely violate this, knowing this is all I've got to pay. That's my fear with the cap. Your cap right now, the way this is written, would be a jury in the county where the case is filed.
Mm-hmm.
And I think to answer your question, it probably depends on the venue. You may see, if there was a suit, you may see an attorney that decides that federal court might be a better venue for them, because this goes again back to your local courthouse where these things would take place.
Right.
Yeah,
Of course, I'm a physician and we run a business too, right?
Yeah.
So, if we're talking about $300, which I think you said was about the most you would have to spend, versus $300,000, it would be a tough business decision, I don't think, from that perspective.
Right.
So,
The decision is less made about the accommodation at the $300 and more about, and we see it every day. We see companies making the decisions to keep a sexual harasser, for example, because they're a high performer, not bring a woman in because they'd have to accommodate it, and bring in a man who could do the job because they wouldn't have absences. So, a law like this obviously incentivizes employers to ensure that they are protecting the women who want to be able to work.
Better hope you don't have the unintended consequence of incentivizing them to hire women that are not childbearing age if they have this exposure that they don't otherwise have. If I've got a choice of hiring a 23-year-old or a 40-year-old, you better be careful. Senator Setzler.
Thank you, Mr. Chairman. I may follow up on some of the things that Pro Tem Kennedy asked, but I won't right now. One thing, you think about this, oftentimes when we kind of tread into new water regulatory-wise, on the federal side, the federal government will mandate it for federally funded entities, then it'll sort of grow to those that are getting a certain amount of funding, then it kind of grows and kind of moves that direction. What does it mean on line 27? Such terms shall not include the definition employer, paragraph 4, means an individual, corporation, limited partnership, and so on. It goes, such terms shall not include a public employer as defined by Code Section 45.1-4. What does that mean?
That means this only applies to private employers rather than the government.
So you're saying the benefit we're providing here, state employees that work in this building wouldn't benefit from this?
State employees actually have their own set of laws that do provide protection already.
So the city of Kennesaw or Forsyth County or Cobb County or any of our counties, this would not apply to their employees?
Correct.
Why wouldn't we apply this to them? If this is a good policy, why wouldn't we apply this to governments?
So you talk about the state. So right now, the state employees, you talk about that.
Yeah, I don't handle much with the state employees, but there is the Georgia Commission of Equal Opportunity that provides laws that provide protections to state employees, and I believe pregnancy discrimination is covered under that as well. Why the decision? I'm not sure why this is applying just to private employers and not to.
But I don't know if that would, as instrumentalities of the state, if that would apply. I don't know if it would apply to county employees. That may be something we need to talk about offline, why we wouldn't want that if it doesn't already apply.
I'm just thinking writ large, if we're going to do this, because we think there's a benefit for work environment, I don't know why we wouldn't be doing it for government. Why would we be requiring private sector employers, but not, and I'm not sure that I'm trying to make it apply to government. I'm just trying to unpack this. Why typically you would see requirements for federal employees, requirements for state employees, and they would work their way down over time. It becomes a kind of commonplace, and the private sector takes it on last. It seems like we're starting with the private sector, but it doesn't apply. It applies to thee, but it doesn't apply to me.
But I'm writing down right now, I want to get more information on what the current state policy is, because I think we already have maybe even better protections for state employees than this may even offer. But let me check on that to get you an answer to that question.
Senator Rett.
I think they just addressed what I was going to ask. If you have federal regulations and you write the state regulation, are we over step one? But I think that you addressed.
Yeah, we do actually have a line, and that would probably also address if we added state employees, that this is not meant to preempt, limit, or diminish lines 116 of the bill. So the bill would not be something you could say, well, if you added state employees, for example, somebody may correct me if I'm wrong, but if we added them, they already had greater protections. This would not diminish that. And so the same thing with federal law. In the event someone decides to pursue under the federal law, this would not impact their ability to do that. Am I saying that correctly?
All right. Senator Hatchett.
I'll be back to you, Senator Setzler, if you'll hold that thought.
I think the chairman and I may have had this conversation this morning. There's a federal law in place now that provides protection for federal employees that are pregnant. That was adopted under, I believe, Donald Trump. And then a couple of years ago, we passed a law that did the same thing for state employees. So they have similar to, if not the same, protection as federal employees. But for private employers, it was not extended. So I think the question that Senator Setzler was asking is, why are we leaving government employees out? Is because they have a separate set of laws that mirror the federal laws. And I think when you're looking at private employers, obviously, I mean, I'm as a father of 4 daughters.
As of today.
As of today, thank you. Unless you know something I don't know. No, I mean, I think it's an important piece of legislation. I do have a couple questions, and I'm glad the author is giving us some time to look at this. And I didn't wait till this afternoon to talk to you. I at least called you this morning.
You're my first call this morning.
But a couple things that I would like to look at is, first off, the undue burden, reasonable accommodation for maternity leave. It's kind of vague whether or not this would apply. If it does apply, what is the length of time? Yeah. I think obviously there would be different interpretations. I don't know what the federal rule is or the state rule, but I believe it may be a month. In some cases, I think that's something that we need to look at and address. I know we touched on it a little bit earlier, but the difference between an applicant, a W-2, a 1099, and then this may be a moot point, but the applicant or claimant, employee, they're all saying these are individuals. Chairman Strickland, you were saying earlier, your wife being pregnant affected you, and you're profession, are we intending this bill to include males, spouses, or is it only for females? I think that may be something we want to clarify in this as well. And then the other idea that I had when we were talking about caps and everything, the punitive damages in this is applicable. That would be applicable are capped at $250 already. Okay. I believe, because I think where there's not a cap is a product's liability, or if there's, I guess, alcohol involved, which I think it'd be hard to justify. But I do think we just want to make sure that is capped at $250, so that there is a cap in here for the punitives. But I would love to work with you more on this over the weekend so we can get something out next week.
And I appreciate it. Just only quick follow-up that he hits the nail on the head of trying to make the balance. Do you draw in this is the leave you can get? Do you draw in this is who it applies to? Or do you kind of put the burden on the individuals in the situation and say, you got to have a request for a reasonable accommodation? You got to look at the undue burden on the business. And it's tough trying to figure out, do we want to codify some of this or leave that for the employer and employee to deal with? And that's the balance we have to figure out. So I'm happy to continue working with you on that.
Thank you.
Senator Watson.
Just point of clarification. I mean, let me understand. So the state now has laws related to this. Is that accurate?
I don't practice with state employees. I believe the answer to that is yes. I don't want to.
But the city and county governments are not.
Not under this law, but they have the federal law that would cover them. So it is not to federal employees, but there is a federal law that would cover county employees.
Well, we can say that for everybody.
Right.
Everybody's covered.
I think there's currently a state policy for state employees. I do not believe there's anything for local government employees or private at this time outside of the federal law.
Yeah. I mean, it doesn't seem right to leave the city and counties from that perspective. And then I didn't quite understand your situation, including you or not including you in the bill.
Because it depends on how it's interpreted, and we may want to clarify that. Right now,
that you would not want to include you, or you would want to include you?
I don't. So my personal experience, I don't think I would be included. Being tired, I don't know what.
And you want to be included, or don't want to be included?
No, I don't care to be included. There may be a circumstance. Though,
just want to clarify that. Okay.
But you may have a circumstance. You don't want me to go there. Okay.
No, I mean,
We've got two other people who want to speak to the bill, too. Senator Setzler, you're recognized.
Keep me on track, please.
Reel it in.
Yeah, I'm sorry, there was one other question I didn't get asked before. What is your intention, just objective, in terms of your objective? It was raised again by Senator Kennedy. Employee means individual who works for or provides services to salary, wages, or remuneration. So is it the goal of this to apply to 1099 employees or even an on-site contractor? For example, if I were an employer and I had a outsourced service, say there was an accounting firm that has people positioned at my site, or somebody that does a service that's not a W-2 employee, they're not even a 1099 individual, they're an on-site, forward-positioned, at my location serving me. What is your goal? Is it to be W-2 only? Is it W-2 plus 1099 or W-2 plus 1099 and a located person who's decidedly an employee of another organization? I just want to understand your goal.
So it's really so the law is about providing accommodations. So if you're not somebody that would be an accommodation requested of, then you're not going to be an employer under the bill. So it's only going to cover those people who are getting payment, who also are able to ask for a reasonable accommodation that the employer would have to be able to provide or not implied. So if you had somebody who was in your location, if you were the one who was in control of whether or not they could take breaks, then yes, then that would be true. But if you were not in control of that person, then you wouldn't be covered under this bill.
So everything from, I mean, I don't want to get too far out there, but I mean, places that businesses are taking some care to give women opportunities to breastfeed at the workplace. Those are all things businesses are doing their job to do, doing their best to do. That kind of thing. If it were a circumstance where you have to get up and do a lot of walking around or rough terrain, perhaps during an employment period of their pregnancy. Hey, it's harder for me now, physically, just the practicality of it. If the job were one in, say, an environment where we're manufacturing, if there's for example, the janitorial staff, for example, that work in a manufacturing plant I might own. I've got a friend of mine that provides janitorial services. So if he has a janitor that's pregnant that's at the site, then the company that furnishes that is the 200,000 square foot manufacturing plant, they would have to make accommodation for my employee who works there every day as a janitor. And if it didn't happen, my employee could actually sue them because they're the one that's furnishing the site.
I don't believe that would actually be applicable under here. Okay. So, it would again come back to who was the one who was in control of that person and the accommodation requested. So if the janitorial service was asking for an accommodation, for example, of a break or not having to clean a particular room, then the question is, who is it that could provide the accommodation? It's very rarely going to be the site owner that's providing the accommodation. It's almost always the employer who's going to say, yes, you're allowed to take an extra break, or, oh, it's okay for you to sit down or stand, or in that circumstance, maybe it's that you don't push the trash cans. You have somebody else who pushes the trash cans who works for us. So the site isn't going to be the one who has control in that way to provide that accommodation.
So if that's the case, I'm just thinking out loud here, Mr. Chairman, is there
All right, let's hold it down now. We ain't recognize you for 15 questions.
Okay.
We got 2 more people on this and 2 more bills to go. You can go ahead and finish it up. Good. All right, you're off the hook for a moment, but we'll have you back. Polly, would you like to speak? Polly McKinney.
Hi, and I'm Polly McKinney, Advocacy Director at Voices for Georgia's Children, and as most of you probably already know, I'm not an attorney, nor am I especially an employment attorney. However, I am a child advocate, and I just want to lend our support to the work that's going on this topic overall and on this piece of legislation. At Voices, as you've heard us say many times, the impact of what happens to a mother while she's working and carrying a child can affect not just the mom, but the infant and the outcomes, and as well as being able to express milk or breastfeed your child can ensure good health outcomes for the baby long term, which trickles on down to fewer insurance claims, fewer days off, better, all those things. And as I was sitting here, I was looking at all my CDC data, thinking, I've already said this to you guys so many times. But what I was thinking about mostly was when I had my children and was in the film business and working right up to the line without any accommodations until my daughter was born 5 weeks early. And then my son was born the day before a shoot. And I just want to say that a lot of those jobs in the film industry are 1099 jobs, and they are long and they are hard. And I was lucky about half of my jobs, people made accommodations for me because they were kind. But I really just want to say I really appreciate this conversation as somebody who was terrified, going into labor, the morning before I was supposed to be on a James Brown shoot. And I was also frustrated because I was going to be on a James Brown shoot. But I just want to remind you guys that there are a lot more jobs that are long and hard that are 1099, because especially in the film business, there's so many freelance people who take on significant work, and it is physically demanding often. And I just want to say from a personal Polly McKinney place that I really appreciate this conversation, and thank you. And thank you to the sponsor.
Thank you. Ms. Sarah Hunt Black Church. I got that right? Blackwell.
Yes, thank you.
ACLU, Georgia. Good to have you with us.
Thank you. Good evening. All right. Good evening, Chairman and members of the committee. I'm Sarah Hunt Blackwell, the First Amendment Policy Advocate with the ACLU of Georgia. It's nice to see some of you again this evening, especially here because I'm here testifying in support of this vital legislation. Thank you, Chairman Strickland, for recognizing the importance of healthy pregnancies and introducing the Pregnancy Protection Act. This bill is particularly crucial for our state because Georgia is among the list of states with the highest maternal mortality rate and infant mortality rates. And it's getting worse instead of better. Last summer, the Georgia Department of Public Health published a maternal mortality report, which indicated that pregnancy-related deaths increased by more than 20% in this state since 2017. What's even more disturbing is that 89% of those deaths were preventable in varying degrees. As we're all aware, it is illegal in Georgia to terminate pregnancies that have reached 6 weeks gestation and beyond. This places an onus on the legislature to help ensure that people have safe pregnancies. Requiring reasonable accommodations for pregnant people in the workplace is a positive and impactful step in that direction. Many pregnant women must work through their pregnancy and are expected to show up in the same capacities, do the same work, and fulfill the same expectations while pregnant, despite having drastically different needs and abilities. These differences should not limit professional opportunities or be a pink slip. We must also remember that even in 2024, access isn't equal, and the impacts of pregnancy weigh heavier on some than others. Some pregnant women are fortunate enough to receive paid parental leave or have external financial support that allows them to take unpaid time off from work. Other pregnant women are on their own, barely making ends meet, or working jobs that don't offer pregnancy accommodations. So SB 283, like a number of other pregnancy protection legislation that have passed across the United States, promotes economic stability for women and healthier outcomes for Georgia's youth. There's a lot of talk these days in the Georgia legislature and beyond about protecting children. SB 283 is part of the economic, physical, and emotional protection that pregnant women need to have safe and protected children. Please vote in support of this bill. Thank you.
Appreciate you being here today. That concludes our public testimony on this bill, and I understand you would like us to hold it, Chairman Strickland. Let us do a little more contemplation before we vote. All right. Well, you got another one, SB 454, if you'd like to come forward and tell us about that one. Okay.
Let me try to shift gears. This hopefully be a little bit quicker. Judge Palmer, you want to join me on up here? Come on up since you're standing. I'll get some. So the Georgia has, and Judge Williford behind me as well, Georgia has a child support commission that some of us in the legislature serve on. In the Senate, there's me and Senator Emanuel Jones. This commission deals with how child support is calculated in our state. There's a lot that goes into it. It's federal law that goes into the requirements of this. There's an economic study that's done every 4 years to update how we handle, or study how we handle, evaluate how we handle child support in our state. If you've never been involved in it, either through paying child support or collecting it, or in my world, dealing with family law cases, child support's formula driven. My staff will tell you they take numbers and they put it into a spreadsheet that's the most updated tables, and it spits out numbers. This bill is, I think for 5 years y'all worked on this?
Something like that.
The commission has worked on updates to our child support statute, and I'll briefly, high level, talk about them and let y'all dive in as deep as y'all want from there. The first part of this is going to update the basic child support obligation table based on a study that deals with changing the top income that you look at from $30,000 to $40,000. You look at both parents' gross monthly income. It also deals with changes when it comes to child rearing expenses built into the formula. Two other parts of it, there's a thing called parenting time deviation that right now is based on whatever lawyers want to argue and however a judge wants to look at it. And it's going to instead create a formula where you have a formula driven based on how much time each parent spends with a child, what kind of deviation there'll be in child support. Same thing with low income deviation. It's rarely used in our state. It's going to create a formula for that. It's only used in about 4% of cases. Frankly, most family law lawyers you talk to don't even know it's there, and so it creates a formula for that. Otherwise, there's general cleanup in this, but those are substantive changes, and I will stop talking and let y'all ask questions or let the experts in the room give us some testimony.
Senator Hodges, you hadn't asked any questions yet today. You paying attention down there? All right, just hit your little button if you want to.
Like child support, you lit up.
You too, Senator Jones. You usually have a lot to add. I don't see any questions for you at this time.
You want to say anything else?
Oh, wait a second, Senator Setson.
Chair's looking for questions. I'll indulge the chair. What's the, if you can break down to brass tacks, what's the change? What's the shift going to be? Where's the move? I get lots.
The short version of it is the high points are that it incorporates the parenting time deviation. The commission adopted a formula. Judge Williford and Katie Connell, who were the head of that subcommittee, but it incorporates that in an easier way, in a more formulaic way that we think will be more fair to parents that have to reflect the amount of time the child is with that parent, particularly the non-custodial parent, the parent that has the child less time into their child support amount. The other big thing that it does is it creates for people at the very low range of the income scale, it gives them a different calculation if you make below $1,500 a month that lowers the amount that they pay. And the reason for that is because there's voluminous data that shows, you know, those people in that category pay child support a lot more consistently if they have an amount that they can handle. And they don't get behind as much, and that's something that we wanted to accomplish in that. And those are the two main things. I mean,
So generally speaking, I'm just breaking it down for a state-centered level, because we get these, I probably have had more phone calls about this than any constituent calls that have gone over 60 minutes of any other calls I've ever had.
About
These issues, right?
Oh, okay.
Yeah, these kind of issues. So in essence, maybe not quite this simple, but the parent that has physical custody day in, day out, in the new formula is going to get more in their apportionment relative to the status quo we're starting from today. That's the direction we're moving. Is that fair to say?
It depends on the case. What's happening right
Yeah,
now with parenting time deviation, as someone who does some of these cases, is it depends on where you are. There's not a standard that we have that's formula driven.
Okay.
And so I can't tell you case by case what the outcome's going to be, but what this is going to do for everybody in our state that litigates in this area and in the courtrooms to deal with this is you kind of have this group. This will create a standard that'll be in place that's formula driven. And so it's not so much where am I in my example, am I in Henry County versus Coweta County or Butts County, and I know I may get a different outcome on how this deviation is going to be used if it's used at all. And this will, is that the best way of putting it? This is going to codify a standard. And Katie litigates this all the time.
Katie Connell, Senator, and you were actually on our list of people that we were suggested to.
Hit the hot seat. Feels good.
Thank you, Judge. We were told we should come and talk to you at some point, and that you might be the person with questions. So, so the big we has turned out to be correct, or the they who told us. But I appreciate your question. I think the best way to describe it, Senator, is that. What this bill does is takes our current system, which does not provide any sort of reliable or consistent connection between the underlying economic concepts in our child support guidelines to the parenting time. From one county to parent to inside the same courthouse, we have an underlying economic system that is not being applied uniformly or efficiently, and therefore often it is being applied unfairly. And so we have non-custodial parents, which does not mean parents who don't have time with their children. It just means they don't have 50% or more, but they might have very, very close to that, who are their economic contributions to their children when their children are with them are not being recognized.
Okay.
And we are looking to rectify that situation.
Perfect. Thank you.
All right, I don't see any more questions. What's the pleasure of the committee? All right, we have a motion to pass and a second. That was Senator Hatchett and Senator Watson came to life down there. And who's the second from? Senator Hodges. All right. Any further discussion or proposed amendments? All in favor, raise your hand. Whoop. Anybody else want to speak? Who are you pointing at?
I was making sure that, you're still on the committee.
Right.
You need to
Rise and be counted.
vote.
Any opposed? It passes unanimously. Very well done, Mr. Chairman. I'm going to give you back your microphone.
Thank you.
Thanks.
Leave that with you because I'm going to take off in a minute or two. Finish up.
Yes. All right. Don't say we're not still hearing House bills. We may hear you last, but we are still hearing House bills, even though we're overwhelmed with Senate bills. House Bill 220, Representative Leverett, Chairman Leverett, if you want to come up. We have a bill we heard last year. I know you'll get right to the point about any changes from the bill that this committee passed out last year. You just couldn't get it on the floor for a vote. LC 442600S.
That's correct, Mr. Chairman. And actually, you've summarized the bill for me. Does the committee have any questions? No, this is a bill that, if you recall, I'm reminded of, was it Yogi Berra's quote, this is like deja vu all over again. You're going to feel like it's deja vu all over again because I did present it last year. This is a bill that deals with a decision called the Deer Lake Condo Homeowners Association that basically said before a homeowners association or condo association can sue to get an injunction for someone to remedy a condition, the wrong, just fill in the blank, for some kind of covenant violation, they have to try to utilize self-help. And that is good law. That law is correct. Before you get equitable remedies, you have to try to utilize the legal remedies you have. And under most of these covenants, there are technically provisions that will allow the association itself to remedy the violation. The problem is people sometimes get shot that way, or they get shot at when they do that. And it's very dangerous for the homeowners association or the condo association official to do that. So what we've tried to do here are really two things. One is we tried to make it where the association doesn't have to utilize that step. And frankly, that's a pretty offensive step. I mean, it's actually going onto someone's property. And so we're alleviating the need to do that first in order to get an order, which usually can then, once you have an order, you can have the sheriff accompany you just to make sure everybody stays safe. But at the request of the realtors, we also added a cure provision that says before any of this happens, the association has to notify the owner, tell them what the problem is, tell them how to fix it, and give them 10 days to fix it themselves. So that is basically the bill, and we do that. You can think of Section 1 and 2. Those both involve the Condo Act, and Section 3 and 4 involve the Property Owners Association Act. And then 5 involves another statute that is older than the Property Owners Association Act, which allowed associations to be formed. And actually most associations now, I'm told, do exist under that older law, but we're basically making the same changes uniformly across all kinds of different associations.
Any questions from the committee? Anybody stop to speak? No one stopped to speak on the bill. What's the pleasure of the committee? Motion do pass from Senator Jones or Senator Setzler. It's second by Senator Kennedy. By committee substitute, all those in favor of the motion, please say aye. Aye. Any opposed? It is unanimous. Who is sponsoring the bill in the Senate?
Am
I carrying it?
That's right.
Why not? I'll have a few for you, hopefully, if I get anything out.
What's that?
If I get any bills out, I'll have a couple for you, hopefully. So.
I'll be glad. Be glad to reciprocate.
Thank you.
Chairman, you've always been very good to me, as has this committee. So
come back and see us again sometime.
I'm sure I'll be back soon.
Thank you, Mr. Chairman. Before everybody leaves, if y'all please meet me over here for a second to talk scheduling next week. But with that, we are adjourned. Well, I can say